Hi everyone, today we will do legal dictation exercise number 3 for High Court and Civil Court. You can get the PDF from description box. So ready? Start. Code of Civil Procedure 1908 Section 25 Transfer of cases. Mere convenience of parties may not be enough for exercise of power. It must also be shown that trial in the chosen forum will result in denial of justice. Code of Civil Procedure 1908 Section 25 Trademarks Violation Suits filed in Delhi against Chennai based institution on the use of DAV transfer of cases to Chennai preyed on the ground of inconvenience, age of president, secretary, language, distance, and that no cause of action arose in Delhi. Age and inconvenience also raised by the respondents opposing transfer same hurdle are applicable to respondents if suits are transferred to Chennai. Further, respondent will have more inconvenience because their 50 other suits are pending in various places and will be very difficult to continue with their suits. Apart from above, following transfer would open floodgates for similarly placed person infringing registered trademarks to approach the court to transfer their suits to the location convenient to themselves all over India and defeat the purpose of Section 134 of Trademarks Act, which confers a jurisdiction with respect to a registered trademark transfer petition dismissed. 1979 4 SCC 167, 1991 SCC 4, 2008 3 SCC 659 referred to. Judgment. P. Sathashivam J. The petitioners in the transfer petition civil number 1233 to 1237 of 2008 and 243 244 of 2009 are schools run by the Tamil Nadu Arya Samaj Education Society. In short, the society, which is registered under the Societies Registration Act 1860. According to the petitioners, the society was registered on 2/1/1975 and has been running and managing schools for the last more than 30 years. The schools are being run under a specific system of education propounded by Swami Dayanand Saraswati, known as Dayanand Anglo-Vedic system, in short DAV. The petitioners have been using the expression DAV with its school for the last more than 30 years. The respondent committee is running about 700 educational institutions. On 16/1/2005, the respondent committee has obtained a trademark registration in respect of the letters DAV and Dayanand Anglo-Vedic under class 41, which is a service mark. On 4/8/2008, the respondent committee is issued a notice to the petitioners of cease and desist, namely, the petitioners should not use the words DAV for its schools. On 28/8/2008, the petitioners, through their advocate, replied to the said notice informing that the schools are being run by the society for the last 38 years with the words DAV. The respondent committee filed 4 suits under Section 134 of the Trademark Act 1999 before the District Court. This Hazari, Delhi, against various schools run by the society at Chennai individually without making the society as a party. Transfer petition civil number 667 of 2009 is filed by another petitioner from Chennai alleging that it is running and managing a school using the expression DAV for more than 24 years. It also raised similar plea seeking transfer of suit number 417 of 2008 titled DAV College Managing Committee versus Dayanand Anglo-Vedic School pending in this Hazari Court, Delhi, to the original side jurisdiction of the High Court of Madras. Thank you. Please subscribe my channel Steno.